The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoy this video and podcast. If you need some help, please give us a call at 563-503-6910. That's 563-503-6910. Thanks for watching and listening.
Hi, this is Andrew with Learn About Law. In this video, we will discuss non-disclosure agreements in Iowa. With more and more companies utilizing big data in decision making and to drive innovation, protecting that data has become a priority, leading to an increase in the utilization of NDAs for new and existing employees. An NDA is a legally binding contract between an individual or entity who holds confidential information, presumably by the employer, and an individual who will receive that information. There is no law against a business requiring a new employee to sign a non-disclosure agreement before beginning to work. The company has the right to refuse employment if the new employee fails to sign the NDA. The situation becomes a little more complicated if the employee has been around for a while and the company suddenly requires him or her to sign an NDA. While this is not uncommon, if the company threatens termination of the employee over refusal to sign the NDA, the employee may have a legal case against the employer for wrongful termination. There are some criteria to consider when determining the confidentiality of any given information. 1. The information is not common knowledge and not generally ascertainable. 2. The information gives an advantage to the business over other businesses in the same field. 3. The business that owns the information has made reasonable efforts to protect that information and has clearly designated that information as confidential. And or 4, the information, records, technology, etc. were developed by or on behalf of the company at a significant cost to the company. However, no matter what a company attempts to include in its NDAs, there are certain types of information that would not legally be considered proprietary, such as 1. General knowledge. 2. Anything available through public record. 3. Any information the new or existing employee had gained through different sources prior to signing the NDA, regardless of whether the company considers it proprietary. And 4. Information that is subject to a subpoena may no longer be considered proprietary in certain situations. If you're not sure whether you should include an NDA in all your new employee paperwork or if you need to have existing employees sign an NDA when moving to a new role, there are some questions you can ask to better determine the necessity of an NDA, including if an employee discussed my internal operations with a competitor, would it harm my business or cause me to lose my advantage over my competitors? 2. If a vendor or client that my company works with divulges information about our sales process, pricing, etc., will it hurt my business in a way that is irreparable? 3. Do I want the legal grounds to discipline, fire, or seek restitution from an employee who is divulging proprietary information to people outside my company? If you answered yes to any of these 3 questions, then you may want to consider seeking the help of a qualified business attorney to draft an NDA. If you have any questions about non-disclosure agreements, give us a call at 630-324-6666. And as always, thank you for tuning in.
Hi again, this is Kevin O'Flaherty. I hope you found this video and podcast helpful. If you need some help, please give us a call at 563-503-6910. That's 563-503-6910. We have several geographic locations for your convenience, and we offer free consultations in many areas of law. Thank you so much for watching and listening.